Okay. All right, the Senate Finance Committee is now in session for our voting, and we'll start with which analyst? Okay, and I would just ask all of us to remember with these masks on, it's hard for us all to hear and for the public to hear well. So we'll all try to enunciate and put a little extra force there.
Okay, are we set?
Yes.
Okay, the first bill on your list is Senate Bill 717. This was held a week ago. The bill alters the process for exclusive representative access to employees in a bargaining unit, primarily new employees. So a couple years ago, a process was set up to allow exclusive representative access to new employees through either a group setting or some new employee processing. This modifies that process. It specifies that an exclusive representative may meet a new employee in person. The meeting may be in person or by video. It also makes similar changes to a separate requirement for employees in a bargaining unit in an institution of state institution of higher education. You have a reprint in front of you. There was some concern. The Department of Budget and Management did not express any concerns with these changes, but the University of Maryland system expressed some concerns with the changes. So the sponsor had meetings with AFSCME and the University System of Maryland and came up with compromise amendments, which both sides agreed to. If you go straight to page 3 of the reprint, first off, and this applies not just to the University System of Maryland, this applies throughout the whole process. It applies to any new employee in the state or a state system institution or Morgan or St. Mary's or Baltimore City, because they're all separate and not part of the USM system. So it clarifies that the starting date of the new employee in a bargaining unit represented by the exclusive representative. Further down, information had to be provided to the union designee or local president within, under the bill's introduced, 24 hours. This changes it to 5 days of the new employee's first check-in. Information excluded, or it specifically provides, although I think that's probably a requirement anyway, that they can't provide the new employee's social security number. And the rest of the amendments specify that everything that is provided to the exclusive representative about the new employee would be considered confidential and may not be disclosed.
Okay, are there any questions? Not, yes, Senator Reed.
Just a quick process question. Why do we need this in law? Is it because they want to be on the clock when they have the meeting? Is that basically why, or?
It is a modification that both sides, I understand, are agreeing to make things simpler for the people involved.
Does the employee have to meet with them?
No, you don't have to be bothered if you don't want to.
Just
The employee does not have to, is not required to meet with an exclusive representative. The existing law already encourages the department to, encourage them to meet, but there's no requirement that the employee meet with an exclusive representative. There's no requirement that an employee has to join the union and pay dues. So
how they do it now? They just,
you know what? Let me. Well, nothing. Go ahead.
That's okay. That's from the hearing.
How do they do it now?
Fine.
Right now? Well, right now, this just modifies what was put in law a couple years ago, and these items were put in law a couple years ago as a result of the Janus decision, which said that you can't do. So they codified a series of steps to access new employees, so they can give these new, so the unions can give new employees the benefits of union membership.
Yeah, no problem. No problem. All right. No, I wasn't here for some of this in the committee, so I'm just trying to be sure I understand the process. All right. Thank you.
All right. Is there a motion?
Move favorable.
Second. All right. We've got a motion and a favorable. Any discussion on the motion? If not, then all in favor, please raise your hand. If you're in favor, raise your hand. Okay. If you're opposed, raise your hand. Okay. Thank you.
Okay. The next bill on your list is Senate Bill 757. This concerns personnel within the Office of the Public Defender. Under current law, the Office of Public Defender employees are they're primarily in the state personnel management system, but they are separate as distinguished by current law. What this bill does is formally move all the employees of the Office of the Public Defender into the state personnel management system by specifically designating them in one of the four services, either executive, management, professional, or skilled. It also, and wherever there's a reference under the law for the public defender to a specific position, it designates which service that position is going to be in. So if you go to page, there's a reprint in front of you. If you go to page 2, you'll see that the deputy public defender will be in the executive service. The public defender is most likely already in the executive service. It designates that each district public defender in the jurisdictions will be in the management service, consistent with the type of activities they do. If you go to the next page of the reprint, all the assistant public defenders will be in a professional service under the state personnel management system, and all the other employees, depending on the nature of their work, will either be classified in the professional service or the skilled service. By putting these public defenders in the professional service, it removes them from at-will status. Currently, under the law, if you look at lines 14 through 17 on page 3, you'll see that public defenders and assistant public defenders are all at-will and serve at the pleasure. By providing them specific designation in the professional service, they become merit-based employees and will no longer be at-will. On the last page of the reprint, there was an amendment offered by the sponsor. Consistent with moving these employees into the professional service of the state personnel management system, under current law, the public defenders are exempt from the state grievance process. If you move them into professional service, it makes sense that they should be allowed to grieve conditions of employment like other state employees. So that is the bill with its amendments.
All right, we have Senator Reed.
Did any of the amendments deal with the opposition of the public defender's office to this bill?
I believe his opposition is to not change anything. He wants them to remain at will. Traditionally in Maryland, attorneys in state government have been at will. All the attorney generals are at will. All the public defenders were at will. There are various reasons for why this has been the case over the years. Mostly it relates to the sensitive nature of the work they do, and they want the ability to, terminate these folks with no cause if they feel necessary. It's not the case that all attorneys in all government levels, agencies are at will. For example, I know the Anne Arundel County attorneys are all in the merit system except for the head of the office. So, but the policy in the state has been to make the attorneys at will employees. This would put them in line with other employees of the state personnel management system and provide them merit system protections.
But also, can you also speak to, I know the budget secretary sent a letter of information, but typically we transfer people into a merit-based system. There's a competitive process.
That has been a recommendation of DBM over the years. I discussed with our attorney generals about this. Why is this so? And there's no reason for that. What happens if you keep all the people in the at will, and then all the new hires come in as protected classes? You have sets of employees sitting right next to each other with different sets of protections. There's no reason to do that. We have a letter from an attorney general I have saved somewhere in my email from Bob Zarnock about 25 years ago that says there's no reason to make this distinction in uncodified language.
Okay, so it's really a policy call whether these folks should be merit or.
Yes.
The other thing the public defender, and I'll defer to somebody else, I guess, after this. But the other thing the public defender talks about in here is that, that basically you're representing clients. So now we're going to put you all together for the purposes of. There's a reason that there's a reason they were at will. There's like a policy reason they're at will. So. All right, I'm just looking. I mean, it's like I see who wants to change it, but I don't necessarily see the why it's so important now. So,
it's a policy call for the General Assembly to make on the status of all their employees.
Senator Feldman, then Senator Hershey.
Well, I'm just looking at, I'm not sure how I'm coming down on this. I'm just trying to think of intellectually, like, we have assistant AGs that are treated, how would we explain that lawyers working in the AG's office are, treated one way, the public defender differently? But I'm looking at the public defender's letter talking about the attrition rate in that office is less than the state average. And the last 3 years, only 2 attorneys have been terminated for cause, and that was because they hadn't been admitted to the Maryland bar. And over the past 10 years, they've only had 30 for cause terminations. I mean, I'm just putting out the question of, if this is about worker protections, when you've only had 2 terminations in the last 3 years, it does raise a question what the problem is that we're seeking to correct.
The problem is that you come in with less in terms of less salary and less of all benefits when you are at will.
Well,
And so what you do is keep people fresh out of college and out of law school, and then as soon as they can get somewhere, you probably right in the middle of people's cases have a lot of people moving on themselves somewhere when they can get something better.
Our Attorney General's office is hiring the same law
students. You couldn't make a career like this.
Okay, well, I just wanted to get that for some discussion possibly. But,
Okay, Senator Hershey.
Thank you. Yeah, that was along the line of my question. And so these are appointed positions currently. They get their job because they've been handpicked, selected by somebody, and says, "Hey, I like you. You've done me a favor. You got a job." And now this bill is going to put them in a permanent position.
They are in permanent positions now. The difference is that if you're a protected employee, you can only be terminated for cause. So
Right.
you would be subject to Title 11 of the State Personnel and Pensions Act. In fact, the bill mentions specifically that they would be subject to the termination provisions which is the key difference to a at-will employee and a merit employee. It's how the termination provisions,
I mean,
basically.
have we thought about doing this with all appointed positions? I mean, why just this department?
Well, because we are the legislators in Maryland. Somebody was interested in this area.
All right,
It
well
doesn't,
then,
so we always
I
come
would
back
say,
next year.
Madam Chair, unless there's another motion with the opposition of the public defender's office, I would just say move unfavorable then.
Senator Augustine, he did have a light on.
I did. I mean, I have some pause on this one too. I'm curious if we have somebody who's a public defender who is not doing a good job of defending, our citizens.
Then you could be fired for cause.
Well, that can be very subjective. I would hazard that there's a possibility, understanding having gone through some of those situations and working with it. I feel this is maybe a little bit of a different sort of situation. It's just something that I think through for sure.
Okay. Yeah, I think everybody's wanted to be heard. Is there a motion from anybody? Okay.
Senator Hershey, motion unfavorable.
What is the motion? All right, Senator Hershey made the motion unfavorable. All right, all in favor of the unfavorable, raise your hand. Okay. All opposed to the unfavorable, raise your hand. Okay. All right, so the unfavorable goes down and the bill passes. Okay.
It's unfavorable.
Is it unfavorable?
It's unfavorable.
Okay, all right. Okay.
The next bill on your list is Senate Bill 801. If you recall last session, there was legislation that was enacted that modified the Economic Stabilization Act. Last year's bill was in response to a recent closing of a large supermarket in Prince George's County, and it resulted in a mass series of layoffs. This bill further alters the guidelines that employers face with a reduction in operations. You have a reprint in front of you. And the sponsor, this bill was the same sponsor of last year's bill. So the bill basically makes clarifications to the whole process under the Economic Stabilization Act as relating to employers and how they have to report reductions in force. If you go to page 2 of the reprint, there was opposition from a particular union to the provisions of the bill. So the sponsor worked out amendments with the opposition as well as the chamber, I believe, was the main proponent of the bill to come up with compromise amendments. So what the bill does as amended, it would clarify what is meant by what the word permanent means throughout the bill. That means an employer has not agreed in a written contract to restore operations within 3 months after the time that the reduction in operations will occur. It also clarifies what is meant by an initial, what may be reduced, what is a reduction in operations, I'm sorry. It clarifies what is meant by a reduction in operations, that it may, but a reduction may reduce the total number of employees at the initial workplace, and it defines initial workplace. If you go to the next page on the changes to the existing law, it also specifies that for the purposes of this act, an employee may not be counted in the determination of a reduction in operations if the employee accepts an offer. So if somebody accepts an offer to transfer to another site within so many days after being offered to transfer, then they can't be counted in a reduction in force. If you go to the bottom of the page, onto the next page, there's changes on who is notified by these reductions in force by employers. And then the main part of the bill is on pages 4 and 5. This is the new language that specifies the circumstances under when an employer is to provide notification under the Economic Stabilization Act. And there are some changes here to the language that was introduced, and basically narrows the circumstances under which the employer may make notification if there's a reduction in force. And again, these are amendments that were agreed on by the opponents and proponents of the bill. And the main proponent was the chamber, and the opponents was a particular union, and the sponsor worked these out.
Okay. Is there a motion? Okay. We have somebody to second? But remember, the public is trying to listen in. They can't tell what in the heck we're doing. So would the maker of the motion raise your hand so we know who made the motion? The motion was favorable?
Motion.
All right. Who seconded? All right, Senator Reed. Okay. Is there any discussion on the motion? Senator Benson?
Yeah, I'm not quite sure I understand what this bill really does.
It clarifies a lot of confusion that exists now.
There's a process in existing law regarding employers that all of a sudden close, and how people are to be notified. Apparently, in Prince George's County a year or two ago, a major supermarket chain shut down operations. Nobody was notified, and there was a lot of disruption in employment in the county because of that. So last year there was a bill put in to further clarify when these reductions in force occur and who has to be notified. This takes it another further and provides additional, basically additional outs for employers who may not be subject to the reporting requirement for a reduction in force. So it further clarifies which employees are going to be affected. And it provides that certain employers may not have to, if they have a reduction in force, report under this act to local governments that they are in fact closing down operations. And there was some concerns about this bill went too far on the employer end by the unions, so the sponsor of the bill negotiated a compromise between the unions and the employers to further limit the opportunities for an employer not to have to report a reduction in force in a particular jurisdiction to local government officials.
So the employers and the unions have gotten together and they're fine.
The employer what?
The employers and the unions have gotten together on this version. Okay,
I know the store that closed down. The
okay.
business, it was
Well, we got a lot of bills, but I just wanted to be sure you got
Yes.
that. Okay, so both sides are together now. Okay, do we have a motion? Okay, all in favor, please raise your hand. Okay. Any opposed, raise your hand. Okay, thank you, the motion carries.
Okay, the next bill on your list is Senate Bill 837. This involves advanced care planning and advanced directives. Senate Bill 837 continues the development and evolution of advanced directives use in the state. It requires the Maryland Health Care Commission to coordinate implementation of advanced directive planning programs across the state for the purpose of encouraging more use of advanced directives in healthcare facilities and by healthcare providers. The bill also requires carriers to offer electronic advanced directives to members. You have a reprint in front of you with an amendment offered by the sponsor. There was, if you go to the back of the reprint, there was concerns by the local health officers regarding providing information on advanced directives while somebody was getting their COVID shot. So the sponsor has offered an amendment to remove that particular requirement from the bill. Otherwise, there are no other amendments to this bill.
Senator Klossner?
No, did you get anything from the Hospital Association?
The Hospital Association? Recently, no. I haven't seen anything from the Hospital Association on this. They were, I thought they were in favor of the bill in their testimony. I don't have my computer with me.
They have an amendment here. I'm trying to find it now.
David, did you receive anything? They have 3 amendments in their testimony.
Oh, I did. It's in their testimony, but
They had asked me today, just recently, if we could talk about them and get them on the bill, so. But
Well, they ought to come more directly, and it's getting late. So do we have a motion?
Favorable.
Is there a second? Okay, it's been moved and seconded that we support the bill as amended. Any discussion on the motion? Senator Hershey?
Yeah, I just thought this was important that we take into consideration what the Hospital Association was looking for. They spoke specifically on page 2, section A, to strike lines 13 and 14, 13 through 18, which dealt specifically with the hospital and the health system. So
what does it really do?
well, again, I think it all has to do with these advanced directives and what the hospitals have to do as a result of this.
But I'm just asking, since you're looking at it, what does it actually do for or against the hospital?
Well, the bill as introduced would, first of all, requires, again, the commission to coordinate all these programs across the state, and the commission didn't have any comment one way or another about being required to do more with advanced directives than they already are required to do. But it does also say that adoption that taken by health systems and healthcare providers, and I'm gathering by the comments, I wish I had their testimony in front of me, that the hospitals don't want to be specifically mentioned in this bill. So you would basically strike out healthcare systems from the bill.
Correct.
Okay, Senator Reed?
Looks like they're concerned about, their letter talks about not wanting there to be like an incentive or regulatory requirement, because then they feel like their patients are going to be feeling like they're doing it because they have to, or they're trying to pressure them. I mean, I'm just saying that's what they're saying. I'm not even sure if I agree with that, but they're saying they're already doing a lot of this, and I don't know. I mean,
Okay, Senator Hershey.
Oh,
Okay. All right, so who wants to make a motion?
We've got the motion, it's favorable in the second.
Okay, all right. We've got a motion and a second. Are you ready for the question? All in favor, please raise your hand. Okay, I'm not sure. 5, 6, 7, 8. Okay, all opposed? Okay, and I'm just abstaining. Because I don't know in this form what it does.
The bill's passed.
Okay, what's the next one?
Consider.
821, the chair abstained.
Yeah, I abstain. I'm not sure now what it does. Okay, all right, go ahead. Okay, we ready for the next
Okay.
bill?
Okay, the next bill on your list is Senate Bill 857. And this bill establishes the Maryland Community Health and Public Safety Center of Excellence within the Governor's Office of Crime Prevention, Youth, and Victim Services. The center's activities must include strategic planning, technical assistance, and state and local government coordination for carrying out its purposes. The bill also establishes priorities for dispersing any federal funds the center receives and requires each local jurisdiction to develop a 2-year community health and public safety plan. The whole point of the bill is to divert people away from the criminal justice system and into crisis services first. All of this diversion would be included in what is labeled as a sequential intercept model. The bill and the amendments implement the recommendations of the Lieutenant Governor's Commission to study mental and behavioral health state summit on behavioral health in the justice system. You have a reprint in front of you. There was a series of amendments offered by the sponsor, and the House is also considering these same amendments that further implement more of the recommendations of the Lieutenant Governor in his commission. I get the impression that the bill as introduced was started the process of implementing some of these recommendations, and the amendments come out and further implement the recommendations. The House has had a subcommittee meeting on these amendments, and there was no opposition to the bill as introduced, and there was no opposition as they work on these amendments. I can quickly go through the reprint, which you have in front of you. First, it changes the name. If you go to page 2, you'll see the name of there's a name change. It's no longer going to be the Maryland Community Health. It's going to be the Maryland Behavioral Health and Public Safety Center of Excellence. There's additional analysis put into the bill that the Safety Center will look at, including a racial impact analysis. There is a change in the definition of sequential intercept model on the bottom of page 2. And that moves over to page 3. On pages 3 through on page 3 of the reprint, there are modified duties of the center. Additional duties in the middle of the page are added to the center, and they go on to the next several pages of the reprint. If you go to page 4 of 6 of the reprint, you'll see that the sequential intercept model the state has to develop a sequential intercept model, which again is designed to divert folks with behavioral health problems from the criminal justice system before they get there. It expresses the intent of the General Assembly about the sequential intercept model. There's a strategic plan required of the center, again, to provide these diversion services, and there are changes on page 506 of the reprint to the strategic plan required of the center for these diversion services. And finally, there's an additional intent added by the General Assembly on the page 6 of the reprint, which are the next steps for the center as it continues to evolve in its processes to keep folks folks with behavioral health problems out of the criminal justice system. Again, the House is probably going to be the House subcommittee will be adopting these similar amendments. There's some clarifying changes being made, but to get the bills crossed and fixed, and there's no opposition, as I understand, to these recommendations.
Okay. Do we have any motion? Senator Hayes?
David, what role are the HBCUs supposed to play in here? On page 2. Are they supposed to be providing
I believe a lot of the studies and a lot of the tasks
research stuff?
Yeah, are going to be assigned to the HBCUs.
Excellent, thank you. I move favorable amendment.
Okay, so we've got a motion
Anything about this?
and a second. All right, is it Senator Reed?
Real quick, I support the concept of the bill, and everything. I just noticing here on page 4 of the reprint, the center shall develop the following: a statewide model for law enforcement assisted diversion. That's fine. This thing about recommendations for pretrial services jumps out at me only from my JPR days, where we've had the issue about requiring a certain type of pretrial process for every county, but almost no county has one because it's extremely expensive. I assume when it says recommendations, it's talking about for pretrial. It's talking about pretrial services for someone who has a mental illness. Is that what this means?
I would think you'd be able to make that assumption, and this whole thing is about folks with mental illness and trying to keep them out of the system.
Which I'm all for. So it's just talking about that. Okay, that's fine.
Okay. All right, if you're ready for the question, all in favor of the bill as amended, please raise your hand. All right. Any opposed? Okay, it looks like it's unanimous.
Okay, and last for me is Senate Bill 914. This is a bill that authorizes full-time sworn law enforcement officers who are deputy sheriffs at the rank of lieutenant or below and court security officers in Baltimore City Sheriff Office. Several other of these types of employees in other jurisdictions already have collective bargaining rights. It would authorize these folks to have collective bargaining rights. There is a letter from the city senators in unanimous support of providing these employees with collective bargaining rights.
Okay, do we have a motion? Can we get a second?
I'll second.
All right, it's been moved and seconded. Any discussion on the motion? All in favor, please raise your hand. Okay, that looks unanimous. Thank you. Okay, Patrick, you're on.
Actually, it's Nathan.
Oh, I'm sorry. I didn't even look to see. I'm sorry.
No, it's all right. First up for me is Senate Bill 459. This is Economic Development, Maryland Small Business Innovation Research Technical Assistance Programs. You have a reprint before you that Senator Feldman is offering an amendment to conform the bill with House Bill 987. This is what was discussed at the hearing. As amended, Senate Bill 459 establishes the Comprehensive Technical Assistance Program within TEDCO. The purpose is to provide comprehensive technical assistance to any business that qualifies for financial assistance under a TEDCO program. And TEDCO is also required to provide a detailed description of the implementation of the program in their annual report.
Okay, any discussion and motions?
Madam Chair, there no
Yes,
opposition to the bill. I'd move favorable.
Okay. All right, we've got a motion and a second. Any discussion on the motion? If not, all in favor, please raise your hand. If you're in favor, please raise your hand. Okay. All right. All right, there appears no opposition, so that passes. Okay.
The next bill is Senate Bill 639. You have a reprint before you that reflects amendments offered by Senator Augustine. If you look particularly at pages 2 and 3, as amended, the bill establishes an inclusion fund within TEDCO. The purpose of the fund is to provide capital investment in technology-based businesses that, one, would qualify for investment under the Builder Fund as provided in regulations. Two, are at least 30% owned by individuals who demonstrate economic disadvantage. And three, are controlled and managed by an individual or individuals who demonstrate economic disadvantage for at least 1 year from the time of investment. TEDCO must include certain...
Let me ask you to back up. What was the last statement, that it's controlled by whom?
Controlled and managed by an individual or individuals who demonstrate economic disadvantage. And then there's this other requirement that it be for at least 1 year from the time of investment. So individuals...
Why would they want a person with disadvantage to control the fund?
Well, an economic I think Senator Augustine has...
That's the point of the bill, Madam Chair. This is about money that for companies, disadvantaged businesses that were in the Builder Fund who need the next round of funding in order to take the next step. That's the reason for this fund. But what they need to be able to do is they need to be able to dilute their ownership share in order to do so. This clause is there to make sure that that disadvantaged person continues to be in the business and that it's not just like a pass-through. That's the purpose of that.
Okay, thank you.
All right, I'll move favorable.
Okay, we've got a motion and a second. Any discussion on the motion, Senator Hayes?
Co-sponsors?
What'd you say?
Co-sponsor?
Okay. Oh, co-sponsor. All right, Senator. All right, anybody who wants to be a co-sponsor, raise your hand so we can get them all at one time. Bill, I may as well be on it too. We got everybody. Okay.
Take the vote.
All right. Did we? I think everybody voted for it. Did everybody vote for it?
Well, Senator Jennings was out of the room.
All right, so everybody. All right, he wants to also be a co-sponsor. Okay.
The next bill is Senate Bill 705. This is Senator Bidel's bill that was held from the last voting session. As a broad overview, Senate Bill 705 requires the Aviation Administration in carrying out its powers and duties with respect to rental vehicles offered by rental companies or peer-to-peer car-sharing programs to treat like services as being of the same class, provide services and grant privileges in a consistent manner, ensure the terms and conditions of agreements are reasonable and uniform, and take into consideration the administration's long-term investment in the consolidated rental vehicle facility. The bill also alters the definition of commercial activity in reference to the administration's authority to approve when commercial activity is allowed at an airport it operates, and adds specificity and expressly includes peer-to-peer car-sharing programs in the activities. There is the amendment that's in the reprint, makes a technical and clarifying change, and then further specifies MAA's authority over commercial activity at BWI extends to a commercial zone that is within a 7-mile radius of the main terminal, and requires MAA to establish rules for the conduct of airport-related commercial activity within the zone.
Okay, any good, Senator Battle?
I just move favorable.
Okay. All right, we've got a motion and a second. Any discussion on the motion? If not, if you're ready for the, Senator Hayes.
Now, my only question is, has there been any changes to the bill with the amendment since we met 2 days ago?
No, there's only been one amendment, and it's the same amendment that was reflected in the reprint that you had at the previous voting session.
Got you. And I had a chance to talk to Senator Biden in reference to my concerns about this bill. For me, it seems to benefit an industry and the main tenet of this industry that in recent history has had some pretty serious accusations put against them and a lawsuit and discriminating against African Americans that's currently pending, which led to the disbarment of their ability to do business with the federal government. And so for me, that's really, really concerning. And the fact that this bill is drafted extends the property of the airport within 7 miles, that almost goes to Baltimore. I think that's pretty extensive. I have grave concerns about who this may benefit. I know the MAA didn't even show appreciation to this committee and come and testify on the bill, and I understand that they're requesting it. But the fact that this is to benefit a main tenet of this industry that has some very, very serious delegations, would lead federal labor department into disbarring them from participation on the federal level as far as contracts. I have serious concerns about this legislation.
Okay. Senator Battle.
Thank you. Thank you, Senator Hayes. So there are 9 rental car companies at the airport. This does not benefit any one rental car company over the others. The problem now is that in a 2018 bill that was passed by this committee, Senate Bill 743, we directed MAA to enter into a concession fee agreement to allow the program to operate at state airports. That concession fee agreement has never been entered into. This bill helps the airport to be able to enter into that agreement. And the 7-mile radius was an MAA request. It was not in the original bill. MAA requested the amendments, and they requested the 7 miles. So there's nothing there. I don't know why they wanted 7 miles, but they wanted 7 miles. So it benefits NextCar, which is a Jack Fitzgerald local company. It benefits Alamo, Thrifty, Budget, Enterprise, Economy, Hertz, Avis, and Sunny Cars in the way that it puts them on equal ground with this peer-to-peer rental. And the old definition for rental car was a fleet, and peer-to-peer is not a fleet. So this bill was necessary to improve the definition so that the airport could enter into a fair vendor agreement as they have with all the other operations on the airport. So I ask for a favorable vote. Thank you, Madam Chair.
Senator Hayes.
Madam Chair, I just want to read part of the judgment here. And it says on July the 17th, 2019, Federal Administrative Judge Morris David issued a 125-page decision and order finding that the Baltimore area subsidiary, located in Linthicum, engaged in a pattern and practice of discriminating against black applicants from 2007 to 2017. This was a week-long contested evidentiary hearing Enterprise lost. The order which Enterprise has complied with to date is to pay $6.6 million in lost earnings and benefits to more than 2,300 black applicants who were turned down from participating in federal contractors management trainee program. They were ordered to offer jobs to 182 discriminated black applicants with back pay and interest and barred from participating in federal contracts per the federal order. With added interest in the cost of giving jobs to applicants they previously rejected, the total stands at $16.3 million, which does not include more than 2 years' interest they have compiled. And I'll just tell you, 2 of those employees were Morgan State University graduates. Susan O'Hare, who works as an income maintenance administrator for the Pennsylvania Department of Human Services. Miss O'Hare is a 2008 graduate of Morgan State University, which is his historically black college, a university. She chose to apply for a management trainee position at that organization because she had previous sales and customer service experience, which matched the management trainee position. Ms. O'Hara said she believed she was qualified for the management trainee position because she had a college degree in sales and customer service. Ms. Michelle Evans' testimony on page 4 of the evidence presented. She was a human resources administrator at Security Plus Federal Credit Union, a position she held for 2 years. 2 years. Ms. Evans graduated in 2006 from Morgan State University. She earned an MBA from Morgan State University in 2016. Of course, Morgan is an HBCU. Ms. Evans learned about the management trainee program from a classmate who worked there. She said it was really good. It was a really good program, and she was interested because she wanted to work for a good company and gain management experience. She said she wanted a management experience she always strived for. And it goes on. There's plenty of Sun articles about this. But in the most recent hearing in the House of Delegates, this was brought to my attention as I had a chance to review it. Our colleague delegate, Janelle Wilkins, asked questions of the employer about this specific lawsuit, and it was denied. They said to that committee that they had not agreed to any type of settlement. But there's plenty of evidence that show, and given the federal government's ruling, I just have serious question that we would, in this body, award an organization that had, and in this time, in this date, award an organization, and this is, and I regret to do, well, I don't, because this is too important, but I've brought this to the sponsor's attention. I know there's grave concerns in the House. I had wished prior to coming here today that those things been worked out. But far too long we can't continue to reward bad behavior. And until this is worked out, I just don't see why we should be advancing this to benefit. And I understand that there's more than one industry. But the fact that the biggest benefactor of this has such harsh allegations lodged against it is very concerning to me. And I can't see myself supporting it. And that's all I have, Madam.
Okay, Senator Biden.
Thank you. There was a lawsuit in 2005, and currently they have 44% of their higher level and entry-level management are African American. They currently recruit at the historical black colleges and universities. There was no disbarment, and they are appealing because they don't feel like all the information was used in that case, so there is an appeal. But this was 2005. This is now 2021, 16 years later, so you certainly hope they learned by any mistakes they made. But the fact that they are recruiting at historical black colleges tells me that they're certainly trying to correct their hiring methods. But again, this is not about one rental car company. This is about all the rental car companies at the airport and the airport's ability to enter into a concession fee agreement that we directed them to do 3 years ago. That's what this bill does, is it allows them to enter into concession fee agreement with Toro and peer-to-peer. And some of the companies masking themselves as peer-to-peer are companies like Allstate Insurance, which now own a fleet. And they're masking themselves as peer-to-peer, and they're not paying the fees, they're not paying the taxes, they're not paying the facility charges. They're using the roads, they're using the shuttle buses, they're using the parking lots. Right now, this is unfair, and Maryland's losing money because the way peer-to-peer is operating. So, I apologize for anything that one rental car company may have done back in 2005, and I know that they are correcting their ways, but we need to do this to correct the issue that's currently going on at the airport where peer-to-peer is not paying their fair share. That's what this bill's about.
Okay, any other discussion? All right, well, we've got a motion, and I think there was a second. Senator Benson.
Madam Chair, can we, I hate to ask you to do this, can we just kind of hold this bill until I talk with the members of on the House side to see what, I need to get more information if I could, please. Is that possible?
How long do you need?
Can we just hold it? When is the next voting session? Tomorrow?
Tomorrow.
When does this committee meet again?
We're voting. Tomorrow.
I don't want to put the bill on
Tomorrow
today,
morning.
but, I mean, I came in here with one opinion to do something, and now, with
We're
this
voting
information that
tomorrow
I'm
morning at
hearing, I'm
9,
just a little
colleagues.
concerned.
You want to hold it until then? So you can,
Can I hold it, please?
all right. Senator Hershey.
Yeah, man, if you want to hold it, I just, again, it's been held once already. I think there's a confusion about bills that we're talking about here. My colleague does have a bill that more or less addresses the concerns that you have, right, that you brought up, Senate Bill 688 into B and T, and you discussed that matter a little bit more based on the taxation and how these industries are taxed. And I think that's the bill that has been seeing some work over in the House. This bill over in the House, from what I understand, is been ready to go, and there has not been this type of conversation about it.
Well,
And
we've agreed to hold it until tomorrow.
that's fine. Thank you.
Okay. All right, where are we going next?
The next bill is Senate Bill 732. This is the Maryland Innovation Initiative University Partnership Pilot Program. There's a reprint before you with an amendment from the sponsor, Senator Patterson, that alters the universities included, but generally the bill establishes the Maryland Innovation Initiative University Partnership Pilot Program, and the pilot program is administered by MII, which is already an entity that exists within TEDCO. The purpose of the program is to expand opportunities at Bowie State University and Frostburg State University for technology validation, entrepreneurial development, and industry engagement. Each university is required to pay an annual contribution of $50,000, and only these universities are eligible to submit projects or proposals for funding under the program. The governor is required to appropriate $500,000 in each of fiscal 2022 and 2023 and 2024 of the program.
Second?
Okay, is there any discussion on the motion? Okay, if not, if you're ready for the question, all in favor, please raise your hand. Okay, I think that's unanimous. Okay, thank you. Okay.
The next bill is Senate Bill 783 from Senator Hayes. You have a reprint in front of you reflecting some amendments offered by the sponsor. Senate Bill 783 establishes the West North Avenue Development Authority for the purpose of developing a comprehensive neighborhood revitalization strategy for the benefit of what is defined in the bill as the target area and a buffer zone in Baltimore City. The bill establishes provisions governing the membership procedures and duty of the authority, and the authority has to report its strategy to the governor and certain committees in the General Assembly by October of 2023. Flipping through the reprint on page 3 of 4, you can see that the president of Coppin State University, or the president's designee, must serve as the chair. It also authorizes the authority to manage appropriated funds from the city of Baltimore and the state. And then on page 4 of 5, authorizes the authority by majority vote to modify the boundaries of the target area and buffer zone.
Okay, can we get a motion?
Second?
Okay, any discussion on the motion? Senator, what is that?
I'd like to hold the bill to our voting session tomorrow to review the amendments.
Okay, all right, you can hold it till tomorrow.
This is a very local bill, and I would warn my colleague, if we want to, if the intention is to be to show retribution, that this is a very dangerous path to walk on. It's not cool. I have serious issues about discrimination in this country, and so I raised them as it related to this bill. I had a conversation with you. This is only relevant to my district. If we want to walk the line of showing retribution, that is not the path that we should take.
What conversation did we have?
Senator Biden, last night I called you, I'll look at my phone. It was about 6:30 last night. Said, Senator Biden, these are some issues that I have concerned with about the airport bill. We had a very cordial conversation going back and forth. I urge you to get in contact with some folks over at ECM because it was my understanding that in reference to your bill specifically, contrary to what Senator Hershey has shared with us, in reference to your bill specifically, that there was some concerns and that there was a work group of individuals that had a conversation. And so in that conversation that I had with you last night, I urge you to reach out to the members of that committee who may have had issues with it and have a conversation with them. And I thought that you guys would work something out or whatever. From my understanding of what came before us today is the same thing that came the other day, and there's no agreement. So we had that conversation last night. Is it not your recollection that we had that conversation
And Senator
last
Hayes,
night?
I reached out to Delegate Lukey, and I tried to reach out to C.T. Wilson. I didn't hear back from either of them. What I found out happened was Ways and Means passed the tax bill with some amendments, but there's been no movement on the cross file. I contacted DFH, Delegate Fraser Odago. There had been no movement on his bill, which is the cross file. I couldn't find anything. I talked with the...
Did have a conversation.
We
Your
did have a
question was,
conversation.
did we have a conversation? And what I said to you, yes, we did have a conversation. I respect you too much to come in here and have you surprised and not knowing what I'm doing. But to disrupt something that only affects my district, that had no opposition, to try to show retribution, that's stepping into another lane that is not acceptable to me.
Well, Senator Hayes, I apologize, but the airport is my district. See, that's the airport is my district, and you keep stepping into my district.
So the airport's bigger than anybody's. Okay. All right.
Chair, I'll take the hold off of this bill, but I'm very distressed about what's happening, Senator Hayes. He did not tell me he was going to hold the bill again today, and I'm very distressed. So I don't know why it's okay for Senator Hayes to hold my bill, and I can't hold it.
Well, if that's what we're doing, I hadn't realized that's what we're doing, but we want to all be big girls and boys. Senator Hershey.
I was just going to go back to the bill. I didn't hear, and maybe it's because I was doing something else, but Commerce did ask if they could be removed as the staff for that.
I want to apologize. I skipped over
That's what I
that
thought.
change that was
Holding
made.
it.
So the provision of the bill, this is on lines 13 and 14 of page 3 of 4. When we add the authorization for the authority to manage and appropriate funds, that's replacing the provision that would have had Commerce staff. So we're striking the Commerce staffing and doing that other thing about authorizing the authority to manage funds. I'm sorry, I just read the new language as opposed to the strike through. So that was my oversight.
Thank you very much. I see it now. Thank
Okay,
you.
thanks for bringing that to attention. Okay. All right, so you have taken your hold off his bill. So we're still then on 783.
Are we ready to vote? All right, and there was a favorable and a second.
All right, let's go back. Who moved the bill before when we had it before?
Senator Augustine, correct, and Senator Benson was second?
Okay, all right. Any further discussion on this bill? All right, if not, then if you're in favor of the motion, would you raise your hand?
Yeah, Senator Jennings?
Okay, thank you. Anybody opposed? Want to be, okay.
The next bill is Senate Bill 824. This deals with joint trenching fees. There's a reprint before you from Senator Hester. This is a second amendment that was received only about half an hour before voting, so I will walk through it as best that I can. But as amended, Senate Bill 824 requires a unit of local government and the Department of Transportation and its subsidiary entities to allow joint trenching by broadband providers on a non-exclusive and non-discriminatory basis. Joint trenching may be denied under certain circumstances as specified in the bill. The bill expressly authorizes local governments to adopt policies to extend broadband access to underserved areas. Local government within the Washington Suburban Sanitary Commission's jurisdiction must allow for review of the policies by the Commission, and MDOT and the Department of Commerce must adopt regulations to implement the bill as specified. It's my understanding, and this was addressed in part at the hearing, that the amendments are intended to address opposition to the bill. So moving through the reprint, the provisions related to the Rural Broadband Assistance Fund are struck. That begins on page 3, continues to page 5. At the bottom of page 5, you see the provision about municipal corporations within the Suburban Sanitary Commission's jurisdiction.
Can we all project? Remember, you got the public maybe listening in. Trying
Sorry
to
about that. On page 8 of 8, it discusses that the department, after consultation with stakeholders, including broadband providers, the Washington Suburban Sanitary District, the Maryland Association of Counties, and the Maryland Municipal League, shall adopt regulations to implement the bill. And then goes on a little bit further, but then finally Section 3 specifies that to the extent practicable, the state shall appropriate federal funding for the purpose of improving broadband access and adoption.
Sounds good to me. Any motion?
Happy bill that everybody likes.
Yeah, I think so. Okay. All right, got a motion and a second. Senator Reedy? Okay, we want to be co-sponsors. Okay. All right. You want to be a co-sponsor? Uh-huh.
Testimony from, I guess, Sean Looney, but it was only oral testimony, so I can't go back and read it. But it was favorable with amendments. Are they the amendments that were put on? Do we know?
My understanding is that the amendments that were put on were intended to address the concerns of industry, and that his concerns would have been addressed.
Because I can only see oral testimony.
You're correct. That is one of the problems when individuals only submit oral testimony, particularly when it's favorable with amendments. We have no way without watching the tape and transcribing what they say to know what amendment they would like to request. So in the future, if you happen to see
maybe
something.
that's something we ought to say in the future. We ought not accept an amendment that is only oral. They got to put it in writing because of all things that create confusion. Senator Hayes.
The only thing I was going to add to that, Madam Chair, in this case, though, in this environment, a lot of people who've been submitting testimony, they've missed that deadline. That 48-hour requirement has been troublesome for somebody. So although they may have, tried to submit testimony, it might have been difficult in this environment.
Okay. Senator Benson.
This bill is extremely important for our children because there are pockets in rural areas, there are pockets in Prince George's County where there has been an absence of broadband. And do you understand that as a result of that, those homes in those pockets have not been exposed to computers, that modern technology has not gone into those areas where there's been an absence of broadband. This is extreme. And those baby children in those areas have not had any exposure to education since the pandemic started. And this bill is so important for our children.
And with the
so
doctor's
I'm going to ask
offices,
you all to really give start support to this bill.
And with the doctor's offices closed in many cases, you can't get telehealth. Okay. All right. So, Senator Hershey.
Madam Chair, I was just going to say I 100% agree with my colleague across there, and so does Comcast.
All right, Senator, anybody else? All right. Did we vote? I don't even know what we did by now. Did we vote on this?
No.
All right, did we have a motion? Yes. Okay, all right, then call for the question. All in favor? All right. Okay. All right, it's everybody. Thank you. Okay.
The next bill is Senate Bill 846. This bill requires the Office of Home Energy Programs in coordination with the United Way of Central Maryland and the Fuel Fund of Maryland to establish the Power to the People pilot program. The pilot program will expand access to the Critical Medical Needs Program and provide training for 211 United Way helpline intake specialists and case managers to serve as navigators. The governor is required to include in fiscal 2023 and 2024 an appropriation of $80,000. There was no opposition to the bill.
Okay. Okay, do we have a motion? Okay, motion and seconded. All right, all in favor of the motion, please raise your hand. All right, anybody opposed? Okay, that's unanimous.
Okay, the next bill is Senate Bill 983, which establishes various requirements for the Department of Labor in administering the unemployment insurance program. This bill was held from the last voting session for Senator Reedy to offer an amendment. The packet in front of you reflects a set of amendments that were also adopted by the House. And in addition, there is a provision on page 5 that is offered by the sponsor, Senator Rosa Pepp, that deals with information sharing. Senator Reedy's amendment is attached to the back of the packet. It's not incorporated into the reprint itself because Senator Reedy's amendment does not affect or touch any of the sections currently addressed in the bill.
What is it, kind of an addition?
It is. So what Senator Reedy's amendment does is that it generally would transition Maryland from being, for the duration of the state of emergency related to the pandemic and for 6 months after, from being what's called a mitigation state for purposes of unemployment insurance determinations to being a pay and deny state. So mitigate in a mitigation state, when someone applies for unemployment insurance coverage, or rather makes a claim for unemployment insurance, rather than receiving a straight denial for eligibility, the state is required to follow up and determine whether a claimant's misconduct, a reason for quitting, or refusal to take another job has any mitigating factors that warrant a reduced penalty. Under the pay or deny system, claimants would be denied more quickly and then would be allowed to move towards an appeal process.
Yes.
All right, Nathan, are you finished?
You can go ahead.
Okay. Well, the appeal process usually takes 4 to 6 weeks for completion under normal times, and who knows how long it's going to take right now. But making Maryland a pay-deny state at this time won't help the situation that we're currently in with the unemployment crisis. And the Department of Labor has invested millions of dollars to increase staffing to help with the backlog of the adjudicated claims. And at this time, switching to pay-deny only shifts the burden from the adjudicators to the appeals team within the Department of Unemployment Insurance. It will do nothing to help claimants who are waiting for their benefits at this time. They're still going to be waiting, and people awaiting adjudication, the people that are contacting our offices every day will have their claims denied by the department should we switch, which means they will still be contacting us wanting to know why their claims were denied. And we will tell them they have the right to appeal, which will create a backlog of appeals. And as I said at the beginning, it takes 4 to 6 weeks for completion under normal times. And who knows how long it's going to take right now. So I don't like that amendment at all.
Okay, Senator Reed.
Am I allowed to explain the amendment from my perspective first before we tell everybody it's bad or what? I mean, no, it's not. I'm not mad at you. Yeah, I understand. So here's the reason I'm offering this amendment. Right now, we're one of only 4 states that does mitigation. And mitigation, getting rid of mitigation, and I drafted the amendment to be temporary so that it wouldn't be permanent. Some of the biggest backlogs are people that are going through mitigation, and some of the worst cases we hear about and we deal with are ones they've gone for 3 or 4 months. Quite often it's a complicated case where because they're going through mitigation. If people could get, denied quicker, they can appeal quicker. Right now you can go through mitigation, be denied, and then appeal. This would allow us to temporarily try to clear a backlog and allow people to apply more quickly if they get denied. Sometimes people get denied, they just want to know what's going on, they can get on with their life, or they can appeal. They can already appeal now, though, so the idea that it shifts it to the appeals process, I'm sure there is some shifting there, because if you denied more people, it'd be appealed right away. But the point is, you're trying to find a way to streamline some of this backlog, and the mitigation thing really does slow this down. And in normal times, there may be perfectly good arguments for mitigating, although, again, we're one of only 4 states, and the other 3 states are not like California, New Jersey, and New York. It's like Alaska and one of the Dakotas or 2 of the other states. So it's not like a blue state, red state, big business versus little guy thing or anything like that. This, to me, seemed like a very common sense way that the Labor Department has been telling us that some of the ones that the worst cases we hear about, as far as when I say the worst cases, I mean the ones that are, I hear about. I haven't heard in 3 or 4 months. A lot of times it's a complicated mitigation issue. And so the thought with this amendment, and it's not, I chose this bill because this bill is an omnibus bill. So I didn't want to offer it on one of Senator Krausmeyer's bills because those were very specific and targeted. Senator Rosenpep had more of a kind of an overall bill, so I thought it was appropriate to bring it up in this. I had a bill on this that has not gotten out of rules. So that's why we didn't have a hearing. So I wanted to offer and I made it temporary so that it's not something, I understand making a full policy change forever might be a bit much for an amendment. So I would offer the amendment and as a way to try to help us deal with this backlog that we're all getting in our offices. And so I would offer the amendment.
All right, before we vote on you, I would like to make a comment. I did serve for 9 years on that UI committee, and Senator Klausmeyer is she's the chair of the Joint Committee on UI. And I think it's a lot more complicated as to what is going on. And I'm not sure that the amendment is sufficient to deal with the scope of the problem. They're really structural problems that I understand because I sat there for 9 years. And that with her in the current chair, I think we may need to listen a little bit.
The only thing I can say, too, is we are in the middle of this whole process. We've been doing it one way for a whole year, and then you're going to stop and go for 6 more months, and then go back to the other one. It's not going to work right now.
Okay.
I mean, and if it's something that we think that we should study, or it can go into the study bill, we could do that.
Okay, let me just ask you, Senator, would you want to consider not putting it right now?
Well, it doesn't have a second yet, so But I think we should study the issue. I don't know if there's a way to
It's
do
a
that.
bigger problem than the way it seems to most of us standing on our side, just trying to deal with our helpless constituents. Senator Hershey.
I would think the same thing. It might be a better opportunity to take a look at this somewhere else, maybe with the joint UI committee, because I think there are some very valid points to it. I wish you did have a bill hearing on it that we could hear more. But just to have to vote on this right now with the limited information would be a little bit tough.
Okay. All right. I appreciate you being accommodating. I think we'll end up with the better outcomes going the other route.
maybe we can talk offline about how to include it in some studying so we can figure out what's going on with it.
We have the study bill and things that we really felt like they need to be looking at, and we might be able to include that. But-
All right, Senator Augustine.
Thank you. I think that having heard all that we have heard, I would move favorable with the conforming amendments and the additional amendment from the sponsor, which was a reporting.
Okay. All right. Are you any further discussion? Are you ready for the question? All in favor, please raise your hand.
My hand's raised.
Okay.
Okay.
Gotcha.
Okay.
We have one more bill and then a withdrawal to tackle, but the last bill for voting today is Senate Bill 933, which was heard just earlier this afternoon. It requires the Office of the Commissioner of Financial Regulation to submit a report to the General Assembly by December 31st of this year, analyzing the banking environment in the state. There was no opposition.
Okay. Any discussion on that motion? All in favor, please raise your hand.
He's outstanding, Senator Benson. Bill.
Yeah. All right. Okay.
And the last piece of business is the withdrawal of Senator Young's bill, Senate Bill 557. The title is Suicide Treatment Improvements Act. We have already moved another bill from Senator Eckert related to the suicide.
Okay, can we get a second? Okay, all in favor of the motion, please raise your hand. Okay. It looks like it's unanimous. All right, thanks so much. And as you heard earlier, colleagues, we're right up to the wire. We're voting 9 o'clock sharp in the morning.